Muted.
Looks like we have both counsel connected, so we'll go on the record in Tomasi versus Tomasi. This is case number 2319198. And if I could have both attorneys put your appearances on, please.
Good morning, Your Honor. Elliot Blumberg on behalf of Diana Jean Tomasi, the plaintiff, who's appearing via Zoom from my office.
Good morning, Your Honor. Mark Dundon appearing on behalf of Dan Tomasi, defendant, who is appearing via Zoom from his work, I believe.
Okay, thank you. Mr. Blumberg, from your side, can you just give me an update on where things are at or what we want to proceed with today?
Sure, Judge. Everything has been resolved in this matter. The parties participated in a mediation on March 1st, which resulted in a resolution of all the issues in this case. A judgment's been prepared. There are some slight revisions that need to be done. And I believe we're still waiting on a child support recommendation from the friend of the court. Other than that, we're ready to take the proofs today if the court would allow us to do that.
Okay, Mr. Dundon, any objection to that?
No, that's correct, Your Honor.
Okay, Mr. Blumberg, if you can angle your camera and I can swear your client in.
Absolutely.
Thank you. Ms. Tomasi, if you'd raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Blumberg, proceed whenever you're ready.
Thank you, Judge. Anna, could you state your full name for the record?
Diana Jean Tomasi.
And you are the plaintiff in this action, is that correct?
Yes.
You filed a complaint on February 1st of 2023, wherein you allege that you married Daniel James Tomasi on December 2nd of 2006 in Clark County, Nevada. Is that correct?
Yes.
And that ceremony was performed by an individual who was authorized to perform marriages.
Yes.
In your complaint, you further allege you had been a resident of the state of Michigan for at least 180 days immediately preceding the filing. Is that correct?
Yes.
And a resident of Otsego County for at least 10 days before you filed your complaint. Is that correct?
Yes.
There were 2 children born of this marriage. Is that correct?
Yes.
And you and Mr. Tomasi entered into an agreement whereby you were going to have primary physical custody of Ava and Alexandria. Is that correct?
Yes.
You're going to share joint legal custody with your husband. Is that correct?
Yes.
You allege further in your complaint there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed?
Yes.
Is that true today?
Absolutely. Yes.
You understand that pursuant to the agreement that you've entered into, you will not be receiving spousal support, nor will Mr. Tomasi, and neither one of you are going to be able to come back before the court at a later date and ask for that. Is that your understanding?
Yes.
You are not currently pregnant, is that correct?
Correct.
Now, you did, as I indicated, entered into an agreement through mediation whereby you are going to be awarded the marital home in this matter, free and clear of any claim that Mr. Tomasi has. Is that your understanding?
Yes.
And that you will have the obligation to refinance the debt within 90 days of the entry of judgment in this matter. Is that also your understanding?
Yes.
Mr. Tomasi has an interest in a business that you are relinquishing any claim to. Is that also your understanding?
Correct. Yes.
You and Mr. Tomasi have entered into a parenting time arrangement which you believe to be in the best interest of your children. Is that correct?
Correct. Yes.
This agreement in terms of property and divisions of debt, do you believe that to be both fair and equitable?
Yes.
Are you asking the court to ultimately adopt your agreement and which will be incorporated into this judgment of divorce?
Yes.
Is there any likelihood that the marriage can be preserved?
No.
Thank you. Judge, I don't believe I have any other questions.
Thank you. Mr. Dundon, did you have any questions for Ms. Tomasi?
No, thank you, Your Honor. I just have a couple brief ones for my client, if possible.
Okay, Mr. Tomasi, if you could unmute yourself, please. Here we go. And raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, sorry. Dan, you heard what Mr. Blumberg said, correct?
Yes.
And you're in agreement with that?
Yes.
Okay, and we engaged in a pretty long mediation with an attorney, correct?
We did.
Okay, and then all of the issues were resolved in that mediation, correct?
Yes,
And you understand you're also waiving spousal support in perpetuity, correct?
I do understand. Yes,
Okay, and you understand that you guys are gonna have joint legal custody of the children, correct?
yes,
And she has primary physical,
correct.
and the other terms pertaining to the children, you think they're in the best interest of the children?
I do.
Okay, and you think the property division was fair and equitable?
I do.
Okay, no further questions, Your Honor.
Thank you. Mr. Blumberg, did you have any questions for Mr. Tomasi?
I do not, Judge.
Okay, thank you. The court finds, based on the testimony of both parties, that the statutory grounds for divorce have been met. The court will grant the divorce. And I'm just going to note that the parties will submit the closing documents. And we'll go from there. Mr. Blumberg, I know that you're waiting on a recommendation from front of the court. Any thoughts on how long it might be until we have all the final documents ready?
Judge, the parties just recently filed their most recent tax return. I don't believe that information has yet been provided to the front of the court. We'll make sure that it gets over there, and hopefully we can get a recommendation pretty quickly.
Okay, Mr. Dundon, is that your view as well?
That sounds right to me. That should work, Judge.
Okay, so I'm just gonna note the next 30 days. If it takes longer than that, if one of your offices could just notify my office so that we know that it's still in progress. Thank you.
Thank you.
Okay, thank you. That's all for today, and both sides are free to disconnect at this time. Okay, whoever signed in under the name Ann Julia, can you tell me your full name, please?
And Julia Phillips, thank you.
Okay, I have your hearing set for 11:45 today.
All righty, thank you.
Okay, thanks. Mr. Goff, are you there? If you are, can you turn on your camera, please, and your microphone?
Oh. Hello.
Here we go, Mr. Goff. Are you able to hear me okay?
Yeah.
Okay, we're on the record in Brandenburg versus Gard. This is case number 093272. Mr. Goff, I believe you were arraigned previously or had a hearing previously with the referee, and a PR bond was set in this case. Ms. Krause is here on behalf of friend of the court. Ms. Krause, can you tell me where things are at from friend of the court standpoint on this file?
Yes, good morning, Your Honor. You are correct. There was a hearing in front of the referee and a PR bond was set. and he was conditionally released from the jail. The conditions of the release was for the defendant to appear today before Your Honor, unless $4,000 payment was made before today, which it has not been. The last payment was made of $100 in October of 2023, and the defendant has a support obligation of $324 and a balance of $15,462.47.
Okay, Mr. Goff, when can you make another payment here?
So I was actually going to try and make one before the court date just to get one in there, but I could probably do one right here within a week or a couple of days. I wanted to get one in before the court date just to try and do something on it, but probably right here within a couple of days.
Okay, and how much of a payment can you make?
Probably like $100 to $300, maybe $100 to $200.
Okay, can you make $300 within the next month? I mean, whether that's in, $100 increments or, all at once, but can you do 300 in the next 30 days?
Yeah, I should be able to come real close to that. I should be able to make that.
Okay, so Ms. Kraus, I'm going to ask that you set this for another hearing at the court's May motion day. And then I'd like to have an order from front of the court that Mr. Goff will make a $300 payment between now and that point, and his bond will continue, and then we'll see where we're at that 30-day mark.
Okay.
All right, thank you. So Mr. Goff, make sure that you make that payment and stay in touch with the friend of the court, and then we'll see where we're at next month, okay?
Okay, I'll get on it.
Okay. All right, thank you. That's all, and you're free to disconnect at this time.
Thanks. Have a good day.
Okay, and then Ms. Kraus, we also had Fultz versus Fernell. That's case number 1817445. That was set for 9 a.m. It's now 9:15. I don't see either of those parties present in the Zoom waiting room. Was that one still on the docket today?
Yes.
Okay. Did you want to issue a bench warrant then for Mr. Fernell for his failure to appear today?
Correct.
Okay. Anything else that we need to put on the record on that file?
Give me just 1 second to review.
Sure.
Outside of any payments that have been received, anything since the payment received in March of 2023 was a non-voluntary payment. It looks like almost every payment received in the last few years have been non-voluntary.
Okay. And then did Mr. Fernell was previously arrested and posted a $300 bond, is that correct?
Yes.
I think, has that already been forfeited to the account?
No, if that could be, that would be appreciated.
Okay, yeah, if you can add that to the order for the bench warrant.
Will do.
Okay, thank you. That's all I have. Are there any other matters that you have?
I do not.
Okay, thank you, and you are free to disconnect.
Appreciate it. Thank you.
Okay, if I could have you both unmute, please.
Yes, sir.
Thank you. Sir, you're Anthony Weber, is that correct?
Correct.
And ma'am, you're Serena Weber?
Correct.
Okay, we're on the record now in Weber versus Weber. This is case number 2319475. The record should reflect both parties are present before the court here today by Zoom. This is set as a status conference today, just to see where things are at and whether or not we're ready to finalize the divorce in this case. I do see that there was back in February an order entered regarding custody and so forth. So my question, Mr. Weber, starting with you as a plaintiff, in terms of dividing up any assets or debts of the marriage, have you guys been able to reach agreements as to those things?
Well, as far as we're just doing split everything down the middle.
I'm sorry, could you repeat that?
We have, from what I remember.
Okay. All right, Ms. Weber, do you agree with that?
Yeah, we already came up with an agreement that both of us have signed on.
Okay. So what I can do then is set this for a final hearing to finalize the divorce. What I need from you guys prior to that hearing, it's a form called the judgment of divorce.
Correct.
And that's the final form that the court signs to finalize the divorce. So I'll need you guys to fill that out and to get that to the clerk's office prior to that final hearing. And then you also need to get a final support order from friend of the court. So there's two forms that you need to turn in prior to the final hearing, and that's the judgment of divorce and then the final support form from friend of the court. And if I have both of those turned in prior to that next hearing, then I can take the testimony that I need to take from each of you to establish the grounds for divorce, and then we can have things done and final on that day. Mr. Weber, do you have any questions about that?
No.
Okay. Ms. Weber, do you have any questions?
No, I do not.
Okay, so I will set that final hearing. You'll get notice of that in the mail, just like you did for today's hearing. It'll be by Zoom, and it should only take 10 minutes or so tops to finalize things. And that's all I have for today. And you're both free to disconnect. Thank you.
All right,
Thank you, Your Honor.
Okay, the next matter we had was Renkevich versus Renkevich. That is file number 2319259. That was set for 9:15 today. It's now 9:21. Neither party is present in the Zoom waiting room. I do note it appears that back in February, we had a hearing at which the defendant failed to appear. So this is now the second failure by the defendant, and I believe the first by the plaintiff. The court will set this for one more hearing in about 30 days. If neither party appears at that hearing, the court will consider dismissing the case in its entirety. And that's all for the record on that file. Our next hearing is set for 9:45. The court will be in recess until that time.
Hello?
Hi, Mr. Goddard, are you able to hear me okay?
Yes, now I can.
Okay, great. So we'll go on the record in Goddard versus Goddard, and this is case number 2319521. The record should reflect Mr. Goddard is present today by Zoom video. This hearing was set for 9:45. It's now 9:48. I do not see Ms. Goddard present in the Zoom waiting room. And Mr. Goddard, this is a conference for the court to set dates for going forward to get your divorce action resolved. The first question I have is, do you have any, have you and Ms. Goddard, are you still on speaking terms? Have you had any discussions with her about how to divide up any assets or debts of the marriage?
We don't have any assets or debts or anything. We just want a
Okay.
simple divorce and just be done with it.
Okay. When did you file for divorce in this case? Back in
Oh.
November?
Yes.
Okay. So, as you may be aware, when there are minor children involved, there's a 6-month waiting period before the court can finalize the divorce. So
Okay.
what I can do is set this for a final hearing in May. Well, actually, you filed on November 22nd, so it would have to be at the beginning of June, which would be past the expiration of that 6-month period. And then the court could finalize the divorce at that time, okay?
Okay, awesome.
So there are 2 things that I will need you to do prior to that final hearing date so that we can
Okay.
finalize the divorce at that time. And there are 2 forms that you're going to need to get. One of the forms is called a judgment of divorce. And if you have a packet documents, you might already have it.
Judgment of divorce.
Correct.
Oh, okay.
And then there's another form that you're going to have to get from the friend of the court office, and that's a final order on child support.
Final order. Okay.
So prior to that final hearing, you'll need to have both of those forms turned into the clerk's office here at the courthouse downtown, okay?
Okay. Okay.
As long as you have those turned in, then we can finalize the divorce at that time. If you don't get those turned in, then we, essentially we won't be able to finalize it. So we'd have to set for another hearing after that.
Okay.
Do you have any questions about any of that?
No, I thought this was for child support, something to do with child support, but because they had sent me some forms and to fill out for child support. They were charging Miss Goddard child support every month. Now they're trying to get me to pay child support only on the sole basis because I make more money than her. And that's kind of not fair for me to give her money just because I make more than her. Like if with my other child, me and her mom have the same 50-50 arrangement and there's no child support because we both share equal time, equal everything.
Yep, it looks like you're gonna have another hearing. That's all handled by the friend of the court. So it looks like yeah, if you have any questions about that part of the case, contact the friend of the court office, okay?
Okay, thank you so much.
But you do need to be in touch with them regardless because again, you're gonna need to get that final support order from them prior to our final hearing.
And
Okay.
how do I get the judgment of divorce? Is there a form I could pick up there? Or?
Did you get some forms online to file for divorce in the first place?
Yeah, I used Michigan Legal Help, that Michigan Legal Help website.
Yes, if you go to that same website, you can get that judgment of divorce form there as well.
Okay. Okay, thank you.
I think it walks you through filling it out and everything right online.
Okay. Okay, thank you.
Okay, great, thank you. That's all for today, and you're free to disconnect at this time.
Okay, have a good day.
Thank you. Okay, we had one other hearing set at 9:45. That was Totton versus Totton, case number 2319468. It's now 9:54, and neither party has appeared on that file. So the court will set Totton versus Totton for one more hearing next month. If neither party appears, the court will dismiss that file. Next hearing is set for 10 a.m. Okay, if I could have council unmute, please. Thank you. We're on the record now in Martin versus Heller Martin, case number 2419564. If I could have council put your appearances on.
Good morning, Your Honor. Jennifer Dusman-Coy on behalf of Bob Martin, who I see is present via Zoom.
Morning, Your Honor. Melissa Riley on behalf of defendant Susan Heller Martin, who is also appearing today via Zoom.
All right, thank you. I saw this case on my docket. I have personal relationships with everybody involved in this case that would make it inappropriate for me to preside over this matter. So last week I directed Jennifer, my assistant, to start the process of reassigning the matter. But rather than try and cancel and get it off of today's docket, I thought I just would notify council here on the record today. Ms. Dukes-McCoy, anything that you wanted to address in that regard?
No, I appreciate the court's candor in letting us know that there is that conflict, and I guess we'll just wait to see who the case is assigned to.
All right, thank you, Ms. Riley.
Nothing to add to that. I just echo Mrs. Coy's comments to the court.
Okay, thank you. That's all for today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
All right, Mr. Dundon, are you able to hear me okay?
Yes, I can, Your Honor. Thanks.
And can you see the individual that's on the Samsung device?
That's Ms. Fox, Your Honor.
Okay, great. So we'll go on record in Fox versus Fox, case number 2219143. The record should reflect that Mr. Dundon is here on behalf of Ms. Fox. This hearing was set for 10:15. It's now 10:18. I don't see Mr. Fox appearing today. I know that Mr. Leonardson had previously represented him and then withdrawn. And I don't believe Mr. Fox appeared at the previous hearing last month either. So Mr. Dundon, how did you want to go forward today?
We were I feasibly was gonna file a default motion. Well, we answered the complaint, so I've got to sort this out. I tried calling him the other day. Unfortunately, this case involves very few, if almost any assets. The primary issue was custody, which we're still waiting for Mr. Fox to file another motion for parenting time if that's what he chooses to do. But we've been waiting, I think maybe 8 months. So I'd like to enter a judgment on the divorce case, Your Honor, but I guess I have to get my affairs in order to get that done.
All right. Well, I mean, I think you'd be entitled to a default at this point, at least as to, the division of any assets or debts and entry of a default judgment. This is a second hearing that Mr. Fox has failed to appear. So in my view, that's an adequate basis to enter a default.
Could we put the proofs on the record, Your Honor? I guess I don't, or if you.
Yeah, I don't have an objection to that if you'd like to do that and then just submit the closing documents later.
Yes, we'll do, Your Honor, if possible. Thanks.
Okay, so Ms. Fox, I'm going to need you to unmute, please. Thank you. Ms. Fox, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand, and Mr. Dundon, feel free to proceed.
Okay, thank you. Please state your name for the record.
Carly Fox?
Okay, and a complaint for divorce was filed in this matter, correct?
Yes.
To your knowledge, had both of you been living in the state of Michigan for 180 days when it was filed?
Yes.
And had you been living in Otsego for 10 days?
Yes.
Okay, and would you say that there's been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Right, exactly.
Okay, yes?
Yes.
Okay, and are you currently pregnant?
No.
Okay, and you understand in the judgment here that we're not going to be asking for spousal support, correct?
Correct.
So you're not going to be getting any from him, correct?
Correct.
And you understand we can never go back and ask for it?
Right, correct.
Okay, and how many children do you have?
2.
Okay, and where are they staying?
They live with me at 1860 McCoy Road.
Okay, when was the last time Mr. Fox has had any parenting time?
That would be, he saw them last time in June, 2 years ago. It'd be 2 years ago this June.
Okay, and as of right now, to your knowledge, we're waiting for Mr. Fox to feasibly file another motion in the front of the court, correct?
Correct.
Okay, Your Honor, sorry, I don't believe I have any further questions.
I just want to clarify, Ms. Fox, the children were all born of this marriage, is that correct?
Yes. Elsie is not the biological child of Jason, but he is on a birth certificate.
Okay, so I guess, Mr. Dundon, that might be another wrinkle here that you may need to address through front of the court.
Yes, Your Honor, I believe he is on the birth certificate and he's acknowledged he filed for custody with both children, but I'll get that squared away, Judge.
Okay. All right, so generally the court finds that the testimony of Ms. Fox meets the statutory grounds for divorce. The court will grant the divorce. I'm going to set this, Mr. Dundon, for a control date in about 60 days.
Yes, Your Honor.
If, obviously, if everything's submitted prior to that point and the court signed it, then I'll just take that off. But I feel like in this case, we may need a control date out there to just touch base if things haven't been resolved.
Probably a good idea. Thank you, Your Honor.
Okay, thank you. Anything else I can address for your side today, Mr. Dundon?
No, thank you, Your Honor.
Okay, thank you. You're both free to disconnect.
Thank you.
Okay, ma'am, are you Haley Crowderfield?
Yes.
All right. And sir, are you Hunter Crowderfield?
Yes.
We're on the record in Crowderfield versus Crowderfield. This is case number 2319399. The record should reflect that both parties are present today by Zoom video. I have this set as a date to finalize the divorce in this case. Mr. Crowderfield, is that how you wanted to proceed today?
Yes.
And Ms. Crowderfield, is that how you wanted to proceed?
No, because he has not sent me my copy of the paperwork with the revisions on it and never sent me the copy without the revisions. I signed his original copy and that was it. And I've been asking him for multiple weeks to send me my copy and he has not.
Okay, so I have one that you signed on February 21st of 2024.
Yep, but there is revisions and with the errors before, I would like to make sure that everything is right.
Okay. All right. Mr. Crowderfield, is there any reason why we can't get that to Ms. Crowderfield so she can sign off on any changes?
Well, the only change that was made was where she scribbled out my name and wrote hers in our last court hearing. We had discussed to just add my name in and her name as well. That was the only change that I made. And I was under the assumption that I just make that change and then turn it back into the county clerks. And when I had spoke with friend of the court and the county clerks just said to make the 3 copies of the original. And none of them had said anything about sending that back to Haley. That is why I did not do that. Because I figured it was just all I had done is added my name into the box that was supposed to be next to her name.
Okay. Yeah, I see that. Well, all right, Miss Crowderfield, I guess, you know, if you want to be able to see this before we enter the judgment, I mean, I think that's fair that you should be able to review it. So it's here at the county clerk's office. You're free to come in and review that at any point. It does look like there has been only that one change made by Mr. Crowderfield, but again, I think it's fair for you to be able to look at the whole thing and make sure that it meets your agreement. And Mr. Crowderfield, I mean, I can't finalize things unless I've got agreement from Ms. Crowderfield on this. So,
Okay.
Ms. Crowderfield, I'm gonna place that burden on you to stop by the clerk's office sometime before the next hearing and review this. And if you approve it, that's great. We'll finalize it at the next hearing. If you don't, then whatever you disagree with, you need to contact Mr. Crowderfield and get that worked out. If you don't come in and review it by the next hearing, then I'm gonna assume that you're in agreement with it, okay?
Yep, I will stop in there.
Okay, great. I will send out notice of the date and time of that final hearing next time, and one way or the other, we'll have it done at that hearing. We won't have any other hearings after that. So whatever you guys need to work out between now and then needs to be worked out. That's all I have for today, and you're both free to disconnect at this time.
Okay, thank you.
Okay, Mr. Rolla, are you able to hear me okay?
Yes, Judge, can you hear me?
I can, thank you. And Miss Ewing, I just need you to unmute.
She still needs to unmute at her end, Judge.
Yeah, I see that.
You want to turn your microphone on?
Her microphone is on, she just needs to unmute. There should be a little button that shows a red mark. You can try calling in too if you're having problems. Okay, so you must not have a microphone equipped on whatever device you're using, so you might have to call in, Miss Ewing, because we're gonna need to be able to talk to you. So if you need a second to do that, then I'll wait for you. Okay, Mr. Rolla, she just sent a message. She's gonna log off and then use a different device.
Yeah, Judge, I read that when she said that into the screen.
Oh, I didn't know if you could see those or not. Okay, good.
Not what she wrote, but I was able to read her lips. It was pretty clear.
Oh, okay.
1 minute. Here we go. Message connecting to audio. There she is.
Okay, now we can hear you. Great.
Okay, perfect. I'm so sorry. My settings on my phone, it was saying that I couldn't access the microphone, so.
Okay, no problem. We're now on the record in Ewing versus Bauer, and this is case number 2319272. The record should reflect that Mr. Roll is present on behalf of the state. Ms. Ewing is also present. This hearing was set for 10:30. It's now 10:35. Mr. Bauer has not appeared. This is set for entry of a default judgment affiliation as well as order for support. Mr. Rolla, I am in receipt of the proposed orders. Is there anything that you needed to state for the record today?
Well, one additional thing as well, Your Honor. I wanted to advise the court that Mr. Bauer contacted our office last Thursday at about 4:35, indicating he's aware of the hearing. He's aware of these proceedings.
Okay, thank you. Ms. Ewing, I've got a few questions for you. Ms. Ewing, you're the mother of Leonidas Ryder, is that correct?
Yes, that's correct, Your Honor.
Okay, and you understand that the order that the court would be entering today would provide that you would have sole physical custody of that child and that you would share joint legal custody with parenting time as you and Mr. Bauer would agree. Do you understand that?
I understand what you're saying, but I am not okay with sharing legal custody with Mr. Bauer or him having access to parenting time.
Judge, if I may give the court some additional information. Thank you. It's my understanding that Ms. Ewing and another party would like to adopt this child. And what she needs to understand is this order needs to be entered before they can proceed with that proceeding. That was where her confusion was, as I understand it.
Okay, Ms. Ewing?
Yes, ultimately that would be the goal, to have the parental rights terminated, or to have Mr. Bauer sign his rights off and move forward to the next step. That would be the ultimate goal.
Okay. So, I mean, if your choices today are either to have the court enter this order on the terms that I've indicated, or I think you'd have to file a motion in front of the court to get a ruling as to whether or not Mr. Bauer is entitled to have joint legal custody. In terms of parenting time, that the order says that it would be as you agree, which means that both you and he would have to agree on it. So, I mean, that to me, that's not really an issue with regard to what you're saying, but joint legal custody is something that you'd have to have a court ruling on that would require at least one more hearing. So that's up to you. I mean, it's your choice on how you want to proceed, but those would be your options today.
Okay, we can move forward. I'm familiar with how that type of custody works, so we can move forward.
Okay, all right. Then, as I stated, the court's also going to issue an order today that would provide for Mr. Bauer to pay child support for your child. Do you understand that as well?
Yes.
Okay, and do you agree that those things would all be in the best interest of your child at this time?
Yes.
Okay, all right. So the court finds that Mr. Bauer was properly served with the complaint in this case, that he failed to answer in a timely manner. In addition, he's failed to appear today, and based on representations of Mr. Rolla, he had notice of the date and time of this hearing today, actual notice, but the court also takes note that he was provided with written notice of the hearing as well, and did not appear. So the court will enter those orders. Ms. Ewing, if you need copies of these, just I'm sure Mr. Rolla's office will make arrangements to get you those. Ms. Ewing, do you have any other questions for purposes of today's hearing?
No, Your Honor.
Okay. Mr. Rolla, anything further for the record from your office today?
So we will provide parties copies after we've got the written order from the court. Thank you, Your Honor.
Okay, thank you. That's all for today, and all sides are free to disconnect on this case.
Very good.
Thank you, Your Honor.
Okay, ma'am, are you Stephanie Bowman?
Yes.
Okay, I have this set for a hearing to enter a default judgment of divorce today. Is that how you wanted to proceed?
Yes.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Bowman, I'm going to be asking you some questions. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. The first thing that I have to state for the record is that Mr. Bowman was properly served with the summons and complaint in this case back in January. He did not answer. He was defaulted in March, and this hearing was set to begin at 10:30, and it's now 10:40. He has not appeared today to contest this divorce. And Ms. Bowman, you filed this complaint, and you signed that complaint. Is that true?
Yes.
When you signed that complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that your marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under this judgment of divorce, you are not going to be receiving any alimony or spousal support. Is that correct?
Yes.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
I understand that.
You and Mr. Bowman are going to keep whatever personal property that you have in your own possession. Is that correct?
Yes.
And you're each going to be responsible for whatever debts are in your own name.
Yes.
And you don't own any real estate or real property together.
Nope.
Okay. All right. And then there is an addendum which provides for the payment of the debt related to, is that a car loan, Chrysler Capital?
Yeah.
And Mr. Bowman's going to be responsible for that. Is that correct?
Correct.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. Bowman. The court finds that the judgment is equitable and contains all the provisions required by statute. So I'm signing that judgment of divorce, which means that as of today, the divorce is final. Ms. Bowman, you're asking to have your last name changed to Graves, is that correct?
Yes.
So from today forward, because the divorce is now final, your name is legally changed. So you will need to change your identification and other documents, okay?
Okay.
And you can get a copy of this judgment from our clerk's office here in Gaylord. Did you have any questions, Bill?
Nope.
Okay. Thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
All right, sir, can you tell me what your name is, please?
Jan Velez.
Okay, thank you. All right, and ma'am, are you Miss Luz?
Yes.
Okay, we're on the record in Luz versus Velez, case number 2219041. The record should reflect both parties are connected today by Zoom video. Mr. Velez, there was a child support review conducted back in January by a friend of the court, and it looks like you objected to the findings there. And then in the middle of February, there was a hearing before the referee, and the referee also denied your objection. So then you've appealed that to this court. Is that correct?
Yes, sir.
Okay. So what we need to do is the court is going to set this for an evidentiary hearing. At that hearing, Mr. Velez, you need to bring whatever documentation that you have regarding your income and assets and debts. The court will take testimony and review whatever documents you have. Ms. Luz, you also have an opportunity at that hearing to question Mr. Velez as to his financial status and to provide any evidence that you would like to provide as well. And then Mr. Velez, the court will make a determination regarding what's an appropriate amount of support, okay?
Yes, sir. Is that hearing going to be in Gaylord, or are we going to do a Zoom meeting again?
The court's required to have any evidentiary hearings like that in person, so that'll be set at the courthouse here in downtown Gaylord. It will be an in-person hearing, so both of you will need to be present. And that's because, you know, I need to review, like I said, whatever documentation you have regarding your income and debts, Mr. Velez, and so I need to be able to review those documents.
Okay, no problem.
Okay. And I'm going to set that for a 1 hour hearing. Mr. Velez, do you think that'd be enough time for you to provide that information to the court?
Yeah, that'd be fun.
Okay. Ms. Luz, do you have any objection to that amount of time?
No, sir.
Okay. All right. So the court will send out the notice of the date and time of that hearing. And again, it's very important that both of you bring any relevant documentation as to the amount of child support with you. And we'll go forward at that time. And that's all I have for today. You're both free to disconnect at this time.
All right, thank you.
Court's next hearing is set for 11:30. We'll be in recess until that time. All right, I think we've got everybody connected here. So we'll go on the record. This is Kuka versus Pulaski, I'm sorry. Case number 2419567. And if I could have counsel put your appearances on, starting with plaintiff, please.
Good morning, Your Honor. David Elkin here on behalf of the plaintiff.
Sarah Ferwetta on behalf of the defendants, the Pulaskis.
All right, thank you. This is set for a hearing today. Plaintiffs have filed their motion for approval and distribution of some proceeds resulting from a settlement in this matter. I did have a chance to review that. Mr. Elkin, did you want to take some testimony today?
I would, Your Honor.
Okay. Ms. Kuka, if you could unmute yourself, please. Thank you. And
Okay.
ma'am, can you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Elkin, proceed whenever you're ready.
Thank you, Your Honor. Could you again please state your full name for the record?
It's Tina Kuka.
Ms. Kuka, on behalf of myself, and I'm sure the court and opposing counsel, we all want to offer our condolences over your loss. We're so sorry.
Thank you.
Could you indicate your relationship to the deceased?
This is my father.
And you understand you were appointed by the probate court to act as the personal representative of the estate of your father, correct?
Yes.
And in that capacity, you hired our law firm to pursue a wrongful death action on behalf of the estate against the alleged responsible parties for the accident of October 18th, 2023, correct?
Yes.
And pursuant to your authority and subject to the court's approval, the matter has been tentatively resolved for the amount of $850,000. You understand that?
Yeah.
And Ms. Kukla, you understand that as personal representative of the estate, you have the right to go to trial in front of a jury, and a jury could award more money, the same amount of money, less money, or no money at all. You understand that?
Yes, I do.
All right, Ms. Kukla, I've gone over the costs and attorney fees with you in this matter, and you're aware that our law firm has incurred costs in the amount of $1,082, and our attorney fee is $282,972, correct?
Correct.
And you understand that leaves net to the estate the amount of $565,945.83.
Yes.
All right. And pursuant to your proposal, the proceeds will be distributed with both you and your sister receiving $275,472.58, and your late father's siblings receiving $5,000 each, correct?
Yes.
Ms. Kukla, is it your understanding that your father passed away instantly and that there was no conscious pain and suffering?
As far as I know, yes.
Do you feel that the settlement is fair and in the best interest of the estate?
Yes.
And knowing what rights you're giving up, Ms. Kukla, specifically the right to go to trial and the amount of money the estate is going to receive, do you want Judge Mertz to approve the settlement?
Yes, please.
All right. I have no further questions, Your Honor.
Thank you. Mr. Wada, do you have any questions at all?
Yes, I just have a couple follow-up questions just to put this on. Ms. Kukla, again, we give your condolences for your loss. As a personal representative of this state, you understand that this settlement includes the execution of a release agreement, a copy of which I believe you've already received and signed?
Yes.
Okay. And as a personal representative of the estate, you signed the release as provided, correct?
Yes.
Okay, that's all the questions I have, Your Honor.
Thank you. Any follow-up to that, Mr. Elkin?
No, Your Honor. I would indicate for the record, though, that all the heirs have been provided with notice of today's hearing and presented the opportunity to object if they had any objections to the distribution. But it's my understanding from talking to Ms. Kukla that all the heirs are on board with the proposed distribution. Is that correct?
Okay, thank you.
Yes.
Oh, go ahead.
I'm sorry, that's it, Your Honor.
All right, this motion was filed pursuant to court rule. Under these circumstances, the court's required to conduct a hearing as to the appropriateness of the settlement and the distribution. The court notes that written notice was provided to all interested parties in this case. This matter was set for hearing at 11:30 this morning. It's now 11:37. No one else has appeared to contest entry of this order. The court has reviewed the motion and the proposed order and heard the testimony of Ms. Kuka this morning. And the court finds that the settlement is fair and equitable and otherwise should be entered by the court. I am in receipt of a proposed order. The court is going to sign that order with today's date. Mr. Elkin, anything further we need to address for the record today?
Your Honor, I just want to make sure there were two orders submitted, an initial order and then a revised order because there was a couple typos in the initial order. I just want to make sure the court signed the revised order for approval and distribution.
Yes, I do have an order that indicates that it is a revised order in its title.
Very good. Nothing further, Your Honor. Thank you so much.
Thank you, Mr. White. Anything further from your side today?
No, Your Honor, nothing further.
All right, thank you. That's all for today. All parties on this file are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Okay, we've got everybody connected. So let's go on the record. We have two files, People versus Mark Allen Pingor, case number 144923 and 4924. If I could have counsel put your appearances on.
Thank you, Honor. For the record, Mike Roll on behalf of the people.
Good morning again, Judge Elliot Blumberg on behalf of Mr. Pingor, who's appearing via Zoom from my office this time.
Okay, great, excellent. So this is set for a hearing today to have two convictions set aside. Mr. Pingor has from 2014, or actually I think 2015 is when the convictions were actually entered. Misdemeanor operating while intoxicated and a felony failure to report. I believe the court's in receipt of all the appropriate documentation from state police and the Attorney General's office. In terms of the statutory technical requirements, Mr. Rolla, do the people take issue with Mr. Pingor's eligibility?
No, Your Honor.
Okay. Then Mr. Blumberg, I guess, obviously with regard to the OWI charge, there's a couple extra considerations the court has to take into account. So did you want to question your client with regard to the findings the court needs to make?
Sure, Judge, I'd be happy to do that. The court will obviously recall when we were last year, Mr. Pingor was attempting to come down from the Upper Peninsula and the Mackinac Bridge was closed. So we started the proceeding and I think that got us to where we are right now. Did you want Mr. Pingor sworn in, Judge?
I typically don't take sworn testimony, and whether you want him to just, kind of present by narrative or whether you want to do it in a question and answer format, either way is good.
We were talking prior to the hearing. I think he's prepared to kind of fill the court into what's been going on in his life since 2015. So Mark, why don't you, first of all, you need to speak up so everybody can hear you, okay?
Okay.
Well, you want me to ask you some questions?
Sure.
Okay, so back in 2015, you had been a school teacher in the Gaylord Public School System, is that right?
Yes.
And my recollection was that you had been teaching for about 17 years. Is that correct?
Not totally, since 2002 in Gaylord, but yes.
Okay. And as a result of the incident that brought you before the court, you lost your job, is that right?
Yes.
Can you tell the court a little bit about what you've been doing over the last number of years?
For the past 7 years, I was hired in at Sioux area public schools in Sault Ste. Marie. I started out the 2 years prior to that, I was doing construction and doing a lot of work around Gaylord, Indian River area. Then I had an accident where I cut my finger off and I had to kind of move and shift gears a little bit. And at that time, I thought it was time to maybe try my hand back in the school systems. So I went up north and applied, and I got a job as a tutor for math and English at an alternative ed building, high school building. And then the following year, a position opened up where they wanted to start a alternative ed program in the middle school. And with my background as an emotionally impaired teacher, in the incentive-based programs that I ran when I was here, they wanted me to fill that position. So I got that job. I started that program. It's an incentive-based program where the students that I get are they're usually on the bottom 10% of attendance, grades, and behavior referrals. And I'm like a tier 3 intervention program. They start with me for 5 hours at least a day. I have one that I have all day, and then they work them way back out into the general ed classrooms. And then also my classroom has like they earn tickets. I have a store so they can be fed. There's standing desks. There's just alternative with some of them have disabilities, ADHD, bean bags. But most of them end up working their way back out into the regular classrooms and move on.
I think the court may have at least some concern about, that one of the offenses that you pled guilty to a number of years ago was a drinking related offense.
Yeah.
Have there been any drinking related issues subsequent to that time?
None.
Have you been through counseling or anything like that?
I was through AA through here, leading up. I did a program while I was in jail, cognitive behavioral therapy, which is ironic because I taught that in my classroom also, but and then went through that. I basically don't have that much alcohol. I definitely will not ever get in a vehicle again. And I guess.
Okay. Judge, I don't know if there's any other information you'd expect us to cover at this time, but I think that addresses at least what I perceive to be the court's concerns.
Okay, I do have two additional questions. Number one of the factors that the court has to make findings on is whether or not it would be in the public interest to set aside both of these convictions. And typically the people will express to the court, things that they want to do in terms of employment, community service, volunteering that they're prevented from doing because of the convictions or things along those lines. Can you have Mr. Pingor speak to that factor?
Sure. Well, Mark, one of the things we had talked about was your desire to perhaps get into education administration. Would that become difficult with these convictions still on your record?
Absolutely. Yeah, I have a master's degree, so I could go into administration. I looked at some jobs, but I just never wanted to really get back into it, knowing that these charges are going to come up in that discussion again. But that, and also at the ISD up there's positions for special ed, transition people, different jobs and I'm coming up on the end of my teaching 30 years. I'm on my 25th year, and I am looking to do something for these last 5 years, maybe in the administration field, if not in the SUE, somewhere else.
All right, thank you. And then you indicated that you did participate in AA. Did you participate in any other alcohol-related rehabilitative or educational programs either before or after you were sentenced in this case?
No.
Okay. All right, thank you. Mr. Rolla, do the people take any position on whether the court should grant the relief requested?
I don't, Judge, but I do have one question that I'd like to ask with Mr. Blumberg's permission, of course, the court's permission, that perhaps can give the court a little more direction.
Sure, please.
Mr. Pingor, what can you tell this court to help the record indicate that you will not have any further issues with alcohol in the future? What steps, in other words, are you taking now or have taken in addition to what you've already said on the record? Why do we believe you won't drink and drive anymore?
I just don't. That was so traumatic, that event and everything that happened with the other person involved, and I just don't even go out usually. If I do anything, it's socially at another person's house, and I don't drive, it's somebody else's, and I don't even drink near as much as I ever did back then. And I can guarantee that I will never step foot in another vehicle under the influence of alcohol. That very traumatic and a big effect on the rest of my last 10 years.
All right, thank you, Mr. Pingor. Thank you, Judge. No, we don't take any issue, Judge.
All right, Mr. Blumberg, anything you wanted to say on behalf of Mr. Pingor today?
Judge, it's interesting, at least to me, you were the judge that presided over the criminal matter. Mr. Rollo was the prosecutor that prosecuted the case. And it was a tragedy all the way around, not only for the victim, but certainly Mr. Pingor's life was turned upside down as a result of this. I genuinely believe when he tells the court that he's never going to drink and then get into a vehicle and drive again. I think the court can trust that he will not do that. And we would ask the court respectfully to grant the request by this petition to expunge those two convictions.
All right, thank you. So again, the court, we're dealing with a felony charge here as well as the misdemeanor OWI, which was part of a plea deal that was pled down from an OWI causing serious injury. And so there's a little bit of a different analysis that the court needs to go through with regard to each of these charges. So dealing with the felony first as the most serious charge, the court notes, number one, that it isn't really a separate felony necessarily. It arises out of the OWI incident here and dealt with Mr. Pingator's employment at the time. The court also recognizes, in having reviewed the file again, that there were some mitigating factors with regard to Mr. Pingator's failure to report to the school back at the time that the incident took place. The court finds that Mr. Pingor, as to the felony, meets all the statutory technical requirements. The court finds that Mr. Pingor's behavior and circumstances since that felony would warrant having it set aside. Mr. Pingor has been gainfully employed. His criminal history indicates he hasn't had any further contacts with law enforcement or the criminal justice system. And he has sought to further his career in education, which the court finds is an extra step that he didn't necessarily have to continue to seek out. The court also finds that it would be in the public interest to have the felony set aside because, again, I think Mr. Pingor being able to pursue other and more opportunities in education would benefit the community as a whole. And certainly being able to put his years of experience to better use than he's been able to do or has been prevented from doing because of a felony on his record warrant having it set aside as well. So the court will grant the request to have the felony failure to report set aside. With regard to the operating while intoxicated offense, the court has to find the things I just indicated. Number one, that Mr. Pingor's behavior and circumstances since the conviction would warrant having it set aside, that it would be in the public interest to do so. But the court also has to consider whether or not Mr. Pingor has engaged in or benefited from any rehabilitative or educational programs, whether they were ordered as part of sentencing or not, and the extent to which Mr. Pingor undertook those things prior to sentencing or after sentencing. And in that regard, I do have some concerns, Mr. Pingor. You know, this incident did involve some significant injuries to another person. You did receive a substantial benefit by the plea agreement and pleading to a misdemeanor as opposed to a felony OWI. You haven't indicated today that you're abstaining completely or have abstained completely from alcohol since this time. While you did indicate that you participated in AA programs, there's no indication that you've participated in any other rehabilitative or educational programs regarding the use of alcohol. And so the court does have concerns in terms of public safety. Your personal guarantees notwithstanding, this is the kind of circumstance and the kind of incident where I think if the court were presented with some evidence that you had engaged in some type of rehabilitative programming or educational programming, that would go a long way towards assuring the court, in addition to your personal assurances, that you would not engage in this kind of incident again. So for those reasons, the court finds that it would not be in the public interest to set aside the misdemeanor OWI conviction because of the lack of evidence of your participation in some professional or organized programming to give you some tools to ensure that this wouldn't occur again. So for those reasons, the court is going to deny that petition. The court is going to provide in that order that you can reapply in a year's time. And I think I kind of explained to you where I see the deficits. And if you're able to engage in some type of programming or have some evaluations done, substance abuse testing and so forth, where you're able to provide the court with some professional findings or professional opinions that that you don't suffer from any kind of alcohol abuse syndrome, and that the court would have some kind of professional assurances that you don't pose a danger of reoffending in terms of operating while intoxicated. So I will provide that in the order. I'm sure Mr. Blumberg can explain that further to you. But again, the court will set aside the felony. The court's denying the application as it relates to the misdemeanor at this time. Mr. Blumberg, did you have any questions about the court's ruling today?
No, Judge, I do not.
Okay. All right. Thank you. I will fill out those orders. Mr. Blumberg did provide those ahead of the hearing, and those will be available at the clerk's office by the end of the day today.
Thank you.
Thank you. All parties are free to disconnect at this time.
Thank you, Judge.
That also concludes the court's morning docket. The court will be in recess until 1:30.